Good afternoon everyone. Hope everyone has good lunch. Now we will start with our talk 3, and before starting the talk we would like to call Professor Manoj Kumar Meshram from Electronic Department and Director of I3F Hub Incubation Center to felicitate Dr. Gitika Shuel, IPR expert. So the talk 3 is about patent filing procedures and IPR registration timeline and filing requirements of patent filing had to be introduced by Dr. Gitika Shuel. Thank you.
Very good afternoon everyone. Hope after the lunch you are not sleepy, although I am a bit. So hope you had a good introduction about what patents is with Dr. Shweta in the morning in the first session. And the different domains of IPR I suppose she has already covered. So herein we, I suppose all other students or the scientists or the professors over here, if we have a basic understanding of patents, how exactly do we need to file, or how exactly, what all the basic requirements one is in need of before filing a patent. So this is all about that. So patent filing procedure and the IPR registration, exactly how it is being executed. You all are aware that if you have an idea, it needs to be, and you want to have a patent on it, it needs to be expressed. So expression of the idea should be there for it to be protected as an intellectual property. The idea can be expressed either in the idea can be either a literary, musical, dramatic thing, or a creation of a logo or a mark as in the trademarks. Or it can be for an aesthetic look of the product, which is in the form of a design, or a product or a process like a patent, or in any other form in which we want an idea to be expressed. It needs to be on the paper. So property, as you all know, that property can be of like the physical thing which you have is it is called property, the real property. Intellectual property is again an intellect of the mind, a property of the mind. So as we have paperwork done for our movable properties or the immovable properties, similarly we need to have some paperwork done so that we need to know that it is being registered on our name. It is our possession. We have all the rights on that. So for that we need to have it got registered, as do we have the registration of all our other properties. What exactly the intellectual property gives you? It gives you the ownership right, the right that you possess it, the right that you can sell it, as it with all other properties. Different types of intellectual properties already is being covered in the morning. We have the patents, we have trademarks, copyrights, industrial designs, then geographical indications, and the trade secrets. So we will be discussing patents first. That exactly because mostly patent is having the largest number of documentation involved when we are filing the patents. What patent is exactly? Patent is a document which the government of any particular country gives you, wherein they give you the exclusive right that you possess the property, you can make, use, exercise, you can license, you can transfer. All these rights the person who is an inventor is having. And an invention is for a limited period, and in exchange for disclosing it in a patent, there is a specification wherein the specification involves all the details which is related to the invention which you have. So these are all the rights which one gets. Patent rights are territorial in nature. You all must be aware that if you have a patent in India, that gives you the right to use, sell, whatever you want to do with that patent only in the territory of India. You don't have a right other than the or outside the territory of a particular country. So the points which needs to be remembered before we are filing a patent is that you need to first protect that patent before publishing it. You all being researchers, you must be aware that before we publish it, before we put it to a public domain, we need to have our rights secured by filing it. Then it gives you a monopoly right, must be aware. It gives a monopoly right to the inventor or to the assignee. It is for a period of 20 years. And saying it that if I have a patent on my name, I am getting an automatic relief. It is not like that. You need, if someone infringes you, you have the right. But if someone infringes you, you can take a legal action against it. As such, you are not protected. But you are given a right that, what we say is that patent is basically a negative right. So negative rights are the rights like you cannot do this. Negative rights are you are not allowed to do this. And rights are basically you should do this. So patents are considered to be the negative rights. And there is a renewal piece associated with all the patents. We consider that once we have a patent on our name, we are through with it. We have all the rights and we don't need to do any further thing. But there are multiple things for its maintenance which one needs to carry on. And many times people also have this perception that for filing a patent, there is a patent agent through which only it should work. But that is not the case. Anyone, if that person is an inventor or co-inventor or assignee, can also file a patent on their name. Although there are a few requirements for it. So what we follow for the Patent Act is the Patent Act 1970 and the Patent Rules 2003. The criteria which one follow for filing a patent are novelty and the inventive step, and they should not fall under the Section 3. I suppose Section 3 is being discussed in details. I just give a brief of that. So Section 3 says if there is any frivolous thing or if there is anything obvious, it need not to be. It cannot be patented. It should not be contrary to the well-established natural laws. It should not be injurious to public health. It's mere derivative of any known substance. One cannot patent. Mere admixture of components cannot be patented. Mere arrangement or rearrangement of a device cannot be patented. Any discovery of scientific principle, method of treatment, any method of agriculture or horticulture, or any mathematical or business method or computer program cannot be patented.
Ma'am, one question.
Yes.
Let's see cigarettes. Injurious for health. Whether there is any patent?
On?
Cigarette.
Cigarette? No, sir. Okay. Good question. No.
And different brand names of wine.
Different, sir, in that.
Coming under this appellate of origin and geographical indication.
Yes, see, not exactly patents. For example, if you want to have your IPR secured with respect to trade, then you can have the logo for it. You can have the trademark for it. So other kind of, even for that matter, for softwares we say, you cannot have a patent, but still, there are ways by which if you have a software, you can, through the systems and other things, you can still have a patent on that. Similarly, when you are saying wine, if that particular thing has a very different composition, from that formulation kind of a thing, or any different microorganism involved, so you can register that particular, or the wine is being prepared from a microorganism which is genetically modified. Then you can definitely have an accession number for that, and then you can think about the formulation, the process of it. But as such, the things, see, there is a difference between discovery and your invention. So anything which is otherwise obviously there. Right. So patent application processing. There are two ways, or the steps which is involved in filing a patent is that you have an idea conceived. Then whenever you have an idea conceived, maybe that for us it is a novel idea, but otherwise it is there already in the public. People already have a patent on it. So what is the first thing which one needs to know is that if there is any other patent otherwise available in any part of the world. So this thing one needs to understand that we have our patent rights which are territorial in nature. So you can only ask someone not to use it, you can only take a legal action, you can only restrict someone not to use it within the territory in which you have the rights. But when it comes to patentability search, any patent which is globally there, anywhere in any part of the India which is being published, because other thing which comes after you file a patent is, it is being published. So if there is any published patent document, it becomes a prior art for you. Now what is a prior art? Prior art is that already similar work is being done related to your work, and that thing, how will you identify that the invention or my idea has already been worked upon is through the patentability search. And there are softwares which are available through which you can identify if your patent or any invention or any idea of yours is already being published in any part of the world. There are few softwares, I suppose must be discussed in the morning, which are Google Patents, which are for free. If you want to search, you want to have a hands-on for that, type Google Patents, look out for your particular research idea, whatever you have through the keywords, and you will be able to identify. But if you want to have a very rigorous patentability search, then one needs to go through different paid softwares and all. So second thing, after an idea is being conceived, is the patentability search. Then a proof of concept with a brief details about what all the invention has to be drafted, and a proper application is being drafted, and then the application is being filed. Now after filing, after 18 months, within 18 months, the application is being published. Then a request for examination is being submitted to the patent office. All the patent application, if it is a complete specification, they will be published, and then if you file for an examination, they will be examined. But unless and until you not file a request for examination, your patent application will not be examined. So request for examination, which has a fees again, should be submitted to the patent office. Then the first examination report. So first examination report is a report. Why we say the first examination report? Because unlike other things, I suppose for having a better understanding, if you are publishing any research article and you are sending it to the respective journal for publishing, there come the reviews. Then maybe the first review cycle comes, then the second one, then the third one. Similarly, for the examination of the patents, there is this first examination report. Because after first examination report, there is again, because it is a legal thing, maybe the controller or the examiner can ask for either hearing or for any further clarification related to your invention. So the first report which patent office submits is called the first examination report. Now after the first examination report, the response needs to be submitted to the patent office, and there is a time duration that within 3 months or within 6 months one needs to submit the response for examination. Then after response for examination, if suppose the controller is satisfied with your response, they do give you the patent registration submission. Otherwise, a hearing is done, wherein further the questions which the examiner has, they ask you and you have to answer it. Then comes the decision, which can be a grant or a refusal. So this is the whole process. Now, where exactly one needs to file your patent application? So it all depends on, first of all, who can apply for the patent application. Any person who is the true and the first inventor of an invention. So true and first inventor means if you are an inventor, it's your invention, you can file a patent. Any assign of the person, you can also assign someone whosoever is a true inventor to file a patent, or any legal representative in case the person is a deceased one. The application for patent can also be done in a joint manner. If there are 2-3 inventors, they all can come together and file for a patent invention. So what are all the different documents which are needed for filing a patent? So the overall process is that once you know that your idea has to be patented, you need to submit an invention disclosure form, which usually a person, if suppose you are yourself are not filing the patent application, then you are given an invention disclosure form which has all the details related to filing a particular invention, patent for the invention. So it contains all the you need to submit all the documents related to the invention. Then on that basis, first and foremost thing, a patentability search is done, wherein as I told you, that to know if similar invention is otherwise already there. So if some invention is similar already there, they will let you know. Then see, I try to identify the differences between your invention and the other inventions which are there. And this also helps one to improvise things to make your invention better. It's not always like a negative or a positive game always. You can also work upon your invention further, looking into the patentability search reports. Then comes the drafting of the patent application. Now, patent drafting can be in two ways. So basically, two ways is a thing of when it comes to patents, what is important is the priority date. So priority date is the date from which gives you, from that particular date, you will be given your all the, like if your patent is being granted, that is the date which gives you the rights of having a patent. So suppose you have filed a patent today, and one of your friends who is working on a similar invention has filed a patent after a month. Now, both of you filed a patent, and maybe the invention is on a similar grounds, but because you have filed it first, you are having a priority over the other person. So this is about the priority date. And you can secure your priority date through the provisional application. And from the complete specification point of view, we file a complete specification at the first place only. We can file a complete specification, or else after filing a provisional, we can file a complete specification later, just to secure the date. Because when we are filing the provisional specification, we don't need to give in all the details. So after filing of the patent, we submit it at the Indian Patent Office, and the application is published within a duration of 18 months. As I told you, there is a provisional application, which is early filing, which is just securing the priority, and then there is a complete specification having all the details related to your patent. What all are the forms? Because with the patent application, it's not just the complete specification, which we also say Form 2, which needs to be submitted. There are other forms also which needs to be submitted to the Patent Office. And this involves Form 1. Now, Form 1 has all the details related to the applicant. Who all are the inventors? At times, the applicant and the inventors are different. For example, in case of ICAR, the Indian Council of Agricultural Research, I work for the organization. ICAR is the applicant in all the inventions. However, the inventors are different. They are from different divisions of ICAR. So, inventor and applicant can be different. And they can be same also, but there is a possibility that applicant can be a person, which can be a natural person, or an applicant can be an institute or an organization. And inventors are the people who are actually the true inventors of that patent application. So in all these forms, they have a fees. There are few forms which don't have a fee, but majorly the forms have a fee. So there is this Form 1, which gives you the detail of the applicant, application and the applicant. Then there is this Form 2, which gives you the details of the invention. So Form 2 is the one which has this complete specification, which has all the details related to the invention. Form 1 is having all the details related to the applicant and the application, and Form 2 is having all the details related to the invention, which includes your title, the background of the invention, any particular of drawings, and drawings also need to be submitted in a particular manner. The brief description of drawings should also be there, as we have the legends in our research papers. Then we have the description, the elaborate description of invention. We have the claims, the abstract, and the drawings. And for your information, the most important part of any patent document is the claims. So whatsoever is written in the claims is basically what you are claiming, is basically the rights which you have been given on your invention. So that the everything which lies is on the how you have drafted your claims. Maybe you have drafted your claim in a manner that you are not being able to get the protection. Either it is being very broad, which is not giving you a very specific detail, or it is very narrow, that you are losing out in some parts of your invention. I will be giving an example later for that. Then comes Form 3. This is basically if you have filed for any foreign filing, if you know about the PCT mode of filing, then if there is any international filing through PCT, then you need to tell about that through Form 3. Then you have your Form 5, which tells you about the declaration as to inventorship. As I told you that your applicant can be different from the inventor, so all the inventors declare that we are the inventors, we are the true and the first inventors, and we give all our rights to the applicant to follow. Then comes Form 18. Usually we file the Form 18 along with our filing of the application at ICR, so that not to miss the deadlines. But otherwise you can file Form 18, the request for examination, within 31 days after your filing of the application, 31 months after filing of your application. For all these for all these forms there is a fees. For example, Form 1 you have a fee of 1600. Now this is in case of a natural person or a startup or a small entity or any educational institute. So before 2017, I suppose, 22, there is this thing like you cannot file under the startup category. The educational institutes were not under the startup category. But then as now the education... Yes, startup can also file under the institutes can also file under the startup category. So we were paying a lot of fees before. For the renewal fees also there was a lot of fees. For the filing also there is a lot of fees. Like professional fee depends if you are a government institute or if you are hiring any attorney. So if you are filing, for example, just to give an example, we at ICR, we have an IP cell. So there are executives who are working on all the IRI ICR application. So IRI is having its own IP cell where all the applications of IIR will be taken care of by the people who are actually either patent agents or they are well to do with the patents. In that case, we have the incubator, the ZTMPPD incubator under which this IP cell falls. They have their own schedule of charges, which are being a government organization, we are having a limited, like the fee is very less. But at the same time, all the scientists, they have this liberty that they can hire any external attorney too, although the charges will be high. So either you cover those charges through your projects or whatsoever means, if you find it to be very productive in invention, at times companies also help you out. Like you have your contract research thing also, wherein companies also come up that you just file the patent and we are going to pay. So these things are covered like that. But otherwise...
This fees is for the government.
This fees is for the government, right? This is...
Service charge is different.
Then there's service charge. So for Form 1, this is the fee of 1600, which is for a natural person, a startup, or a small entity, or any educational institute. So I suppose BHU, IDBHU comes under it. And it is 8,000 for anyone other than natural person or a company. For Form 2, there is because Form 2 is covered, this whole fees of Form 2 filing is basically covered in this Form 1 only. So there is no fees for it. Again, Form 3 and 5, they are basically giving you information related to the application filing only. So there is no fees. For Form 8, there is this fees Form 80 for Form 18, which is your request for examination. So you need to pay, you need to ask the patent office that examine our application. Unless or until you are not going to tell the patent office that with the fees, with the form and the fees, that you examine our application, they are not going to examine it. They will just publish it. That is something which they will be doing when you are filing the patent application.
Let's say we are asking for the early publication
Mm-hmm.
and early examination
Mm-hmm.
together.
Yes. So early publication and early examination, basically once your application has come to early publication, is published, then only you can file a request for examination. So let it be only for in case of early expedited examination, we call it expedited examination. So when your application need to have an early publication, then only you can go ahead with an expedited examination.
We can ask together.
No. No.
Separate.
Yes. Once it's been published, then only you can file for expedite examination. Although otherwise you can file for request for examination, not expedite one. Form 18, which is like for a normal examination, you can file it along.
Until we have to wait for the publication.
Yes. At times what we are doing is we are also filing it, ICR also. We are filing the Form 18 at the time of filing itself. Then later on at times scientists come and then say that we want to go for an early examination, expedite examination. Then we convert this Form 18, for which we have already filed a fee. Because there is a difference in fee. For this it is around 4,000 and for an expedite examination it is around 8,000. So you have to pay that extra 4,000 if you are converting your 18 to 18A.
Okay, instead of 12,000, it should be 8,000.
Not 12,000, sir. Instead of it is otherwise 8,000 only. So suppose you have this 4,000 is already been covered when it is not being expedited. Because you have filed a Form 18 within just filing for a request for examination, not an early or an expedite examination. So the compensation, the amount which is left over, there you can pay and you can convert your application Form 18 into 18A.
Now, I need to clear one thing. Let's say I have filed a patent. And now, next thing should be there asking for the early publication.
So, if you want to file a patent with an early publication, at the time of filing also you can file for an early publication.
Oh, that time also.
That time also.
Whether we need to pay extra?
Yes. There is a fee for Form 9. So
Whether
you,
it's the same amount or it's less?
so see, for this 1600 covers only Form 1, 2, 3, 5. With this 1, 2, 3, 5, your application will be published within after 18 months. But if you want an early publication, you need to file Form 9 for it. And that you can file either after filing or you can also file at the time of filing itself. So with that form, within 3 months only, your application will be published. So Form 18 is the fee for, 4,000 is the fee for Form 18. And if you want to have an expert examination, it is more. So if you see the difference, like it is 5 times the difference of a startup and an educational institute as compared to a company. Now where to apply? This is a question which comes to us because there are other ICR institutes also. To give an example, that they want to know that under what jurisdiction do we fall. So the head office of patents is in Kolkata. But other than the branch offices which fall as per the jurisdiction, where exactly the institute is, where exactly the address or the office address will be there, on that basis jurisdiction is being selected. So it can be either New Delhi, Mumbai, Kolkata or Chennai. So filing procedure, it can be either through the offline mode wherein you are submitting the hard copies, or it can be through the online mode. For online submissions, if for example, an inventor and being a natural person want to submit it on their own, they need to have a digital signature for themselves, and they can also do an online submission of the patent application. Or else you can submit the hard copies, or else you can take the help of a patent agent who is having the digital signature with them. So what happens after examination, or what all are the different hurdles, so-called, which comes when you are filing a patent application? So there is this examination. Now, when your patent application is published, it is now in the public domain. Now people know about it. Now suppose there is a competitor of yours. Then that person, before grant only, can file an opposition. Saying that, see, my invention is similar to yours, under these grounds, they can file a through a legal application, they can go for a pre-grant opposition. This we call the pre-grant opposition because this has happened after publication and before your application has been examined or it's been granted, basically. So you can have a pre-grant opposition. Then after grant also, you can have an opposition. So it's not like that if you have a patent document with you, it cannot be opposed. Although you are having full rights on your patent, but anyone can oppose, saying it, for example, that I have a better priority, before priority, as compared to the one who has been given the grant. So at times you have rejections post-grant also. One can take any legal action even post-grant too. Then you have the annuities. Annuities is, usually it's been considered that once you have a patent being granted, it's yours and there is like, people have these all exemptions. No. But you need to file a renewal fee which needs to be submitted with time to time. Every year one needs to, at times, you can also submit for all 20 years till the time you have your patent document on your name. So annuity needs to be submitted after the grant. Post-grant opposition, ma'am, is usually before the grant. So after the examination is published, it is published after 18 months. Whenever it is being published, anyone can file till the time it is being granted.
So after granting a patent, it cannot be, revoked or something like that?
It can be revoked through post-grant opposition.
So that is what I'm asking. What is the timeline? It can be at any time or?
That can be post-grant is usually like you have to file a post-grant opposition. It needs to be within a time duration, like 12 months only. You need to file a post-grant opposition. But you can do that after grant too. Anyone can. Because it has come to the public domain now. It's being granted also. If a competitor of yours finds it out, it can go for a post-grant opposition. Then working of parents. This is another thing. At times what happens, as in the morning sir is saying that a parent is what it can be a keeping document only. At times what people do is they just have a patent. Then what is the purpose of a patent? The purpose of a patent is it should have a commercialization. So you need to tell that you are working on that patent. It is still being functional. Someone is either doing from research point of view also. You is working on that patent. So working on patent is also submitted in the patent office. So examination. As I told you that the request for examination is submitted by the applicant or any interested party and it is filed within 31 months from the date of filing. There is a formality check, prior art research and everything is being analyzed by the examiner. So basically they, as the papers are being reviewed in a similar manner, they will be giving you documentation through D1, D2, D3 that these are all the prior arts which are already there and you need to tell them on the basis of your novelty factor, on the basis of your inventiveness, that how your invention is not falling under being a prior art. Response for IPR is filed should be answered. Like whenever you are having an IPR being issued, within 6 months duration, you need to submit your response to the patent office. So examination, it is a formal examination which involves all the technical details. Then you have your first examination report, which gives you all the gist of the objections communicated to the applicant. Then the examination needs to be filed for the response by the applicant. And if there is there can be a hearing between after filing the response. If the controller is not satisfied, which many times the controller is, they can ask for hearing, and on that basis they can grant or refuse. Now, when you're talking about the expedite examination, so there are institutes which are central or state or government startups, and all these they come under the category of expedited examination. For this, you need to file a form 18A. The timeline for this is 1 to 2 months, and the official fee is 8,000 rupees. The benefits one gets is that they have been examined.
MSME and startup it is 8,000.
8,000.
But it is within the institute, if any startup is there,
Mm-hmm.
so that fees will be taken as an institutional fees, or is it a...
Ma'am, these all fees, what I'm telling you is the fees which the patent office, you have to submit to the patent office. It is a government fee. This doesn't include the professional fee. This is all the government, this is the basic fee which the government takes for examining your application. So within 1 or 2 months, your application, they give you the IPR response. Now when we are talking about the pre-grant opposition that is filed after the application has been published and before the grant, as I told you. And when is considered only when the request for examination has been filed for it. And can be filed by any person, by anyone. It does not need to be anyone related to the inventor, anyone can file it. And it should include all the statements and evidence because it is basically it is a legal document which tells you all the points of objections. Now, how exactly the patent is being granted, it may take at times. Now their process is a bit better, but it used to take 10 years for a patent to be granted previously when the things were not that smooth.
One thing is that if the invention is under the granted patent for 20 years.
Yes.
From the date of filing.
From the date of filing.
If some patent on application they require 10 years for granting, this means that after granting it will remain only
10 years have gone, sir. But you can, from the prior, basically what they say is that from the priority date, exactly. It needs to be renewed every year after the grant of the patent and it is calculated after 2 years from the filing date. So suppose you have got your patent document granted in the 5th year of filing. So you have to submit from the grant date 2 years initial you leave and then later you should include all the years for submitting your renewal fee.
If we pay the annual fees, it is equal to renew.
No. Sir, renewal fee तो है ही उसी ना?
After 20 years it becomes...
No, he is saying that in one go if he submits it, renewal fee you can submit it in one go also.
Renewal fee and annual fee we pay together for 20 years.
You can do it.
Then it is not equal to renew fund.
Yeah, you can do that too. But if
potential for commercial application, then you can maintain it for 20 years. Otherwise,
Let's say mRNA has been discovered in 2001, but it has been used in 2021 when vaccine is there.
But take one thing, you file a patent, you have filed a patent. After that, if somebody else can use that process and produce without paying any revenue or anything, if it is not published, filing to, publish.
you have filed, sir,
So it is protected.
so it is protected. The day you have
Before publication of some patent, if someone is using
yes. Since the time you have filed it, it's in your name now.
well, that's okay. But
Yeah.
if some
You can take action also. You can take action. You can take a legal action against the people. Although you need to have a clarity because again the other side, the people will also question because who is going to take the decision? The controller will take the decision. So he will listen to both the sides. So if you're fair enough, same process cannot be used. Although, for example, when we are filing a provisional application, we are not giving all the details. We are giving a brief concept note kind of a thing. So there, all the details are not there. Now, if someone comes from that brief information, maybe things are not clear. But if you can definitely take a legal action with all things, all your documentation in place. like see, this is how, because competitors basically know each other with and how, in what all domains are they working, or there are any overlaps or not. So
it is better to find all the details.
yeah, it's better to find any day. Although the window of provisional application from complete specification, it is like 12 months of a window. But it's better always as early as you do the complete specification. So annuity needs to be paid for every year for it to be valid. Failing to pay the annuity on time may lead to patent lapse. And usually if there is a lapse, patent office is very smart. They keep on giving you the deadlines, and then with extra fees, they keep on extending. With extra fees, you can again pay your annuities if you have missed the date. Working of patent through Form 27, you need to give the statement that your patent is still functional. You are working on your patent. It is not something like no one is working on your patent. In the Form 27, you need to submit all the details related to it, and it is mandatory for each year. Now, at times, patent office say that you can submit for coming like 5 years also in one go you can submit your working of patent. And if there is any failure to comply, it can lead to any compulsory licensing. Compulsory licensing, I'm not pretty sure if you know about it. It is like if there is any.
Compulsory licensing?
So compulsory licensing is that the government takes, like all the licensing rights the government takes under their control. So they have and it usually happens in the cases where there is like any public or any health hazard kind of a thing. For example, if there is any vaccine or any medicine which is for the public interest, usually it comes with the public interest. So if something is for the public interest and someone is owing a patent, so the government can have it under their control because it is no more, one person should not be having gains for that. So this is how the Indian Patent Office site looks when you want to file a patent online. So you have to type the Indian Patent Office, then this particular first thing comes, the Intellectual Property India. You click on this. So it takes you to this particular page. Now in this particular page you can see, I suppose, this comprehensive e-filing right herein. The comprehensive e-filing, you go to the comprehensive e-filing, there is this login details. So if you have to register yourself, if you want to file it on your own, you register yourself with all your DSC, the digital signature, which one you should have, and then there comes this pop-up of form 1, 2 to submit and upload with all the details. So this is how the patent application online one can submit along with the fees. With the fees, they have this online portal wherein you can also pay through Google Pay, you can have your NFT and all other means. Now what are the common mistakes which are done by the inventors? They are drafting without any patentability search. They are having inadequate patent searches, they are just using the Google patent and they think that our invention is novel. Application not to be filed within 1 year of public use. This is basically now people do have the knowledge that once they are having their information, they should not publish it, they should always patent, at least to have a priority date. If you don't want to have all the documentation with a complete spec, at least have a priority date secured. And then you can, within 1 year, even if you have done it, try that if you have put it in any public domain or you have in conference or anywhere you have showcased your invention, you should file it. It should have happened within a year or so. Not considering non-patentability, considering that my invention is very novel and it doesn't belong to any, it will not be covered under non-patentability. One should also consider that your invention should consider all the section 3 parameters. Failing to file within 12 months of public disclosure is another thing. Not knowing that they can use different types of intellectual property together. This is another thing. People think that, okay, I can only file patent, I have a knowledge of patents, I don't have any other knowledge. They think that they don't even think that they can have a copyright, they can have a trademark, they can have other things also. They can have a design also. Like at times at ICR, the scientists come to us. They say that, see, this is an invention of ours, which is a novel one. Now again we are using this invention only. We have made a device. Now that device, we want to have an IPR on this device also, and we want to file a patent. Now because they being very similar patent. Now if I file this one patent, patent 1, then patent 2, if I am filing which is having a part of it, it will be a prior art. This patent 1 becomes a prior art for my second patent. So in that case, we suggest them that it's better if you file a design instead of going ahead with a patent filing. Not paying the renewal fee, they think that, okay fine, we have a patent already, there is no need to pay the renewal fee, and later on,
Industrial design has the same fees as in the case of patent.
it's less ma'am,
It's less.
Although the protection is also not that strong.
Yes, 10 years.
Yes. There's a poor drafting of patent claims. Again, this is very important because we think that we just copy pasting things or having already a draft, we can make a patent claims. But what one should consider when having a patent claims is that all necessary part of your information which you want basically to have a claim on, which you want others to restrict, not to use, they should be covered in your patent claims. As I told you, that patent claim is the most important part of any complete spec. Not paying your annuity again, not submitting the working of patents. So these are things which basically after the grant which happens, which usually people skip.
Just give some highlights on the top, that line, failing to file within 12 months of public disclosure.
Okay. So this is what we call the anticipation of patents. So we say that if you have, the patent office says that if you have put anything in public, we are having a priority date. Okay. Now if you are putting anything in public and now you want after 12 months, since the time, suppose it's in this Feb that I have showcased my technology.
In a small room of this kind of gathering or in a form of publication?
See, usually it's been considered that the lesser the people, it should not be like exposed in the public domain, in the sense, suppose it's been advertised for your invention, it's been published in any journal. What will happen is, if suppose it's published in any of your newsletter, anyone can come any other day, taking that newsletter, they have a proof, right? And even if someone clicks a picture of yours, you are in any conference, someone clicks a picture of yours, they can produce that picture, saying that, see, it's been more than 12 months since the time they have done this.
No, if it is within the 12 months, so...
Within the 12 months you are saying?
So prior art is not there?
Not considered. Your invention will not be considered a prior art for yourself
Even if I have published that work?
Yes.
Even if I
Yes. But within that 12 months.
Yeah.
Within that 12 months. So at times, though people do hesitate to publish it before patent, if we know that it is basically the final blueprint of their. So what happens, sir? That we say that you should not be into the public domain till the time, and within 12, if you have done it, within 12 months duration, you should secure your priority date. You should have secured a priority date on the patent.
No, just clear before putting it. After the granting of patent, filing is within the 12 months.
Within the 12 months. Within the 12 months.
If I'm doing it on the 12 months itself.
Yes. So that's what I'm saying. If in first Feb you have showcased it, then by 31st January you should have done the filing.
It is like that, let's say here.
Yes. You can, with that, your invention will not be a prior art for yourself. Within 12 months. Even if you have published it, for that matter. And now within 12 months you should put a patent.
It is like that paper has been published.
Yeah, generally we have restricted ourselves from doing it because
Simultaneously you can do it.
Let us be clear, after filing.
Mm-hmm.
Filing you can publish, no? That's what you're saying.
No. After publications, within 12 months, you can file the patent.
That's what you're saying.
that's what she
Let's say
So we restricted, though, we say that you take a priority first and then publish it. But if you have done that, within that, you have published it first, then take it within 12 months of duration. Now again, when you are saying 12 months, you have submitted it, right? That submission may be the day you have submitted it. That can be considered a prior date, not the one day when you have published in the journal. You have published it in the journal. It has come into as a publication. Because you have given it to the public, right? You have given it to the reviewers. That can also be considered.
Date of submission can be considered.
Yes, that can be considered as a date of, since the date when you have
First communication.
first communication. To avoid things
But this is already
First
circulated.
communication within this 12 months.
within this, considered from that first communication, start counting your 12 months.
Or other way, it can be tell that, let's say you are submitting the document in IPR office, the number, application number should come within 12 months. It should not cross.
No,
I think that's happened before 12.
Yes, application number should come. Application number should come.
Number supposed to come even on the day of 12 months also.
Yes,
इसका
yes.
मतलब यूज पेटेंट ऑफिस की मतलब जैसे मतलब है.
Many.
Yes.
मान लीजिए today is the 11th March 20 days. Now you are planning to have a filing of patent.
Filing of patent, right?
Take time for the drafting.
Hmm.
And in the meantime,
Priority you can take.
and let's say 12 months one day हो गया.
Hmm.
Then it is invalid.
Yes, yes.
Draft submission है.
draft submission,
It
filing
should be submitted in the patent office.
Yeah.
प्रायोरिटी भी ले सकते हैं सर. प्रायोरिटी तो दैट मींस वी से कि प्रायोरिटी ले लो. आपको अगर अभी अपना आपको लग रहा है कि मेरा बिल्कुल उस लेवल पर नहीं है, प्रोटोटाइप लेवल पर भी रेडी नहीं है, यू टेक अ प्रायोरिटी. यू हैव 12 मंथ विंडो ओपन नाउ एटलीस्ट.
नाम डाल के छोड़ दिया.
Draft is not needed.
सर नाम डाल के छोड़ दिया, बट वही वाला हो जाता है ना, प्री ग्रांट अपोजिशन आने के. हाँ, तो बेटर है कि वो करें, टाइम में मतलब कर दें चीजों को, प्रोलॉन्ग ना करें.
बाद में उसको modify
हाँ हाँ. एट टाइम्स ऑफ सर कंफ्यूजन इस बात में रहता है कि पब्लिश करें, पेटेंट करें भी कि नहीं करें. मतलब दिस आई एम टॉकिंग फ्रॉम द पॉइंट ऑफ व्यू ऑफ द साइंटिस्ट वी वर्क विद. दे आर वेरी कंफ्यूज. शुड वी गो अहेड विद पेटेंट?
कंफ्यूजन है. पब्लिश करेंगे नहीं करेंगे, पर पेटेंट करेंगे नहीं.
पेटेंट करें कि नहीं करें.
ये भी क्वेश्चन.
हाँ, पेटेंट करें कि नहीं करें. पेटेंट टू बी ऑनेस्ट जो मेन गोल रहता है, अब वही दिस इज ऑल सेंसिटाइजेशन. एक लेवल पे शुरू होगा तभी किसी लेवल पे पहुंचेगा. सो इफ वी कंसीडर इट लाइक दैट, एटलीस्ट अभी किसी तरीके से पेटेंट करें, बाद में शायद उसकी अंडरस्टैंडिंग क्लियर हो कि हाँ इससे बहुत कुछ अचीव किया जा सकता है. अभी तो ये है कि ठीक है, टू हैव अ नंबर. फॉर एग्जांपल एमईटी, दे आर एडवर्टाइजिंग ऑन द नेम्स ऑफ पेटेंट फाइलिंग. We have this many number of patents being filed. MET, Delhi. So they are just doing it on the name of, basically that is their advertising agenda. That we have filed that many patents. So and that's why patent office is now saying you should not, the NAC accreditation and for all those things, it should be not on the basis of patent being filed, but on the basis of patent being granted. Yeah, publishing or granted of the patent. Grant of the patent is important. क्योंकि आपने फाइल किया, पब्लिश तो हो जाएगा. वो तो आपको अपने आप ही पेटेंट ऑफिस 18 मंथ का के बाद पब्लिश कर देगा उसको. आपने फीस दिया है, पे किया है. हाँ, तो वो पब्लिश करना इज नॉट अ प्रॉब्लम, बट आपका ग्रांट होना चाहिए.
अच्छा लास्ट पॉइंट.
तो अभी आपने इसका ये पेटेंट करेंगे क्या लग रहा है? जो कंफ्यूजन तो आपने नहीं छोड़ा.
सर पेटेंट करें अगर कॉमर्शियली उसका इम्पोर्टेंस है.
कमर्शियली यूज हो.
Commercial use हो.
देख रहे हैं.
सर मगर पता है क्या होता है, बिल्कुल मैं उसको
लिस्ट पर नहीं है.
लिस्ट में.
पीस ऑफ पेपर जमा हो गया मेरे वॉल पे की.
सर मगर देखिए, अगर 100 ऐसी एप्लीकेशन में से एक एप्लीकेशन भी ऐसा निकलता है जो एक स्टार्टअप के लिए इम्पोर्टेंट है,
तो मन को ढूंढना चाह रहा था.
तो वो वन मिल जाए तो वो 100 वर्थ इट हो जाता है.
मेरा भी तो जीरो पे डिपेंडेंट है. आई डिडंट फाइंड एनी पेटेंट.
सर मगर फॉर एग्जांपल देयर प्रमोशंस के लिए पीपल आर आस्किंग अस, लाइक साइंटिस्ट आर कमिंग अस बिकॉज़ कि हमारे पास पेटेंट होना चाहिए, तो मे बी हमारे प्रमोशन उसमें कहीं ना कहीं हेल्पफुल होगा.
पॉइंट सिस्टम आ गई.
पॉइंट सिस्टम. पर ठीक है, और कैसे करेगी गवर्नमेंट एनकरेज? फॉर एनकरेजमेंट्स आपको देने पड़ेंगे ना कि प्लीज गुडीज. हाँ, पीसीटी.
लास्ट लाइन.
Not submitting the working of patent report. Working of patent is important, sir. This is something which is different from the annuity. Annuity तो आप renewal fee दे रहे हो, मगर आप काम ही नहीं कर रहे हो. पेटेंट ऑफिस आप कह रहे हैं ना कि क्या करता है पेटेंट ऑफिस? पेटेंट ऑफिस अपनी तरफ से कोशिश करता है कि काम करो, पुश करता है कि दिखाओ वर्किंग ऑफ पेटेंट दिखाओ. अब बिकॉज पीपल आर स्मार्ट, वो फिर किसी तरीके से दिखाते हैं हमने तो करा है, हमारे इस कंपनी से काम चल, वी आर इन टॉकिंग टर्म्स विद दिस कंपनी, वी आर डूइंग दिस. So
Now, Patent means next thing is that we have to work with the industry.
हाँ, commercialization is suspect. Commercialization is हाँ. तो उस पे काम होना के लिए हाँ, मगर एक बार पेटेंट आएगा तो आपको एक वो भी मिलता है ना, you get a platform जिससे आप कह सकते हो कंपनी को. Many companies also छोटी companies merge हो रही हैं. They talk about it that we want to have the patent. आप अपने IPR secure करो. Then only we will talk about the commercialization. Trademarks के लिए बहुत बार होता है. अब IPR में आप सिर्फ पेटेंट की बात नहीं करते ना. आपके मैं बोलता हूँ ट्रेडमार्क सिक्योर है आपका, तो ठीक है, we can work upon it. हाँ. But sir, accommodations की, for example, contract research हो रहा है. तो आप contract research में उनको तो चाहिए lab ना. Incubators, what they are providing labs to the startups. But अगर scientist है, the other way around also it can work. No, आपके पास lab है. अब आपको कॉमर्शलाइज करना है, वो एस्पेक्ट्स नहीं पता, कंपनी के साथ कोलैबोरेट करने के लिए वो करो. कंपनी के लिए फिर देन फाइंड आउट द कंपनी टाइप, इवैल्यूएटिंग योर टेक्नोलॉजी, कैसे कितना होगा, कितना प्राइसिंग होना चाहिए मेरी टेक्नोलॉजी का, नो हाउ देना है तो क्या देना है, नो हाउ आप देने में कैसे रिस्ट्रिक्ट करोगे अनलेस अनटिल यू डोंट हैव एन आईपीआर. एनीवन कैन कॉपी. आप कॉमर्शलाइज कर रहे हो, आपके पास आईपीआर नहीं है, एनीवन कैन कॉपी. तो वो आपको सारे एस्पेक्ट ऑफ कॉमर्शलाइजेशन आल्सो नीड्स टू नो. So international patent filing procedure, I don't know if it is of much importance to you guys, but I'll take some. So IPR, it refers to the legal rights and it is for a period of some time. Then these are exclusive rights which the inventors or the creators have. They are territorial in nature. This is something which we already know. Now, when we are saying that the patent rights are territorial, now if someone wants to have a patent, which is although international patent is not a term, but if someone wants to have a patent which is in multiple countries, one wants to have it, we file there is a route through which we can do it. So for this, either so for example, if I want to file a patent, I am filing in one single country. Or you can also, you have a patent in India, now you want to have a patent in US, you directly go to US patent office and you can file a patent. This is one way.
Protection under.
It is a global patent.
Global patent.
Global patent. With a single application, file a global patent.
This is through PCT. Through PCT route, one can do it.
Protection under Paris Convention.
So, yes. So Paris Convention.
This is PCT.
This is PCT. So, sir, what happens is, what is PCT? Basically, there is this treaty which has been signed in which there are these countries which have come together and they are saying that these all countries, if you want to have you want to file a patent, there is no need to get into the individual countries. Through PCT route only, you can file in this one platform, and later on you can go to the individual nations, wherein you have to pay the fee for the individual nation, but there is this one place where you are filing, wherein you will have your patentability search to know that there is not a prior art involved, and there is an examination which will happen in individual countries. But then it's just route, they are giving you a route through which you can do it instead of going to individual countries altogether.
Plus, we are getting the priority.
You are getting the priority.
One example, let's say, before filing the India patent, you can go directly to the PCT.
Yes, you can go directly to the PCT. For that, you have to find, there is this FFL, there is this form, the first filing form, which you have to show that you have filed it in India. Not exactly priority filing, but through that you secure a date in India, and then you file, and then you can do immediately, instead of filing in India, you can directly go to PCT.
And later I have to file in India,
You can file it.
or we can do reverse, file in India and then.
Yes, that is the best route, but if you want to do it otherwise, that also you can do. So protection under PCT, so when we are talking about this Paris Convention, you are having different country members. So there are overlapping members also through PCT, where you have 157 members. Then through Paris Convention, again you have some 179 members. So what are the different routes through which you file? You can file the national patent going to the individual patent offices. Or you can go to the regional patent office. What are these regional patent offices? For example, you have ERIPO. So all the African nations, you can file one patent in the ERIPO, wherein in all the African nations, if you want to file, later on you can go for the examination in individual nations. Suppose there are 10 nations, you want to file it in 2 nations only, you can go for the examination in that. हाँ, और वो काफी वो डॉलर्स में होता है सर, बहुत अच्छी, लैक्स में होता है वो. Then comes the PCT route, wherein there is a single receiving office. So PCT is basically the World Patent Organization, which through single route wherein you can file the application. You file it this particular office, then it can go to the individual national offices and or the regional offices, for example this IPR and all, and then you can have your filing being done.
Ma'am, assume that I have filed a patent to US. Yes.
You have filed a patent in US Patent Office, and now you want to file in other countries also. No, you want to have if you want to have a protection in all over the world, like you want to have a protection all over the world or in majorly some nations, then you have to go to that individual nations through PCT. Individual nation as in through PCT you can go to the later on with the examination you can go to the individual nations. Or if you know only 2 countries you want to go, then why to go through PCT? You can individually file in these 2 countries itself.
How much would it cost for PCT?
Good amount, sir. Because it depends on the attorneys over there. It depends on the examination fee in that particular country. Yeah, it is different for different countries. You can't generalize. No, you don't have to. For PCT, you have to file in PCT. One application in PCT. They will be doing a patentability search on that. So they international patent search report, we say it. So internationally they search the patent. They give it is like they are giving a validation. PCT is giving a validation that this doesn't have any other prior art. This is novel. Now it can be taken to individual patent offices, wheresoever the applicant wants to place them. So if an applicant wants to place them in 2 countries, they can opt for those 2 countries. They have to then go to the national level in those 2 countries itself, wherein they have to pay the fee for examination there. So through PCT you are just clarifying you are bringing a clarity to your invention. It has a potential to be filed in these countries as a patent. Yeah. Yes. Not patent in India. A filing in India, not even a priority filing. Just you have to take a priority filing from India through a document, which is a different, we call it FFL, the initial filing document. And from that also you can file it. Yes. Just filing, not like a proper patent filing form 2, form 1, not that base, but like a different form is there, which you file, and then you can go ahead with the PCT route. Mm-hmm. 12 months. It become a prior answer.
Within granting 12 months.
Within filing 12 months. Within filing. वो प्रायर हो गया ना सर, वो इंटरनेशनली भी प्रायर हो गया. ग्रांटेड के बाद 12 मंथ्स चला गया, ग्रांट नहीं भी हुआ, 12 मंथ्स चला गया, आपने इंडिया में फाइल किया, 12 मंथ्स चला गया, अब आप पीसीटी फाइल नहीं कर सकते. तो ग्रांट 12 मंथ्स से पहले हो गया, तो आप जा सकते हो. वो एक्सपीडिएट करेंगे, पब्लिकेशन एक्सपीडिएट करेंगे, पैसा दे दो. हाँ. तो वो जो एंटिसिपेशन वाला टाइम है ना सर, 12 मंथ्स का विंडो, वो आपका हर जगह पे आ जाता है. हाँ, वो आपका इंटरनेशनल पेटेंट फाइलिंग में भी आ जाएगा. तो यू नीड टू कंसिडर दैट. So PCT is an international patent law that provides a unified procedure for filing of patent and protection of your invention in the contracting countries. It is an through international treaty this is being done. So you have, this is being taken care by the WIPO, the World Intellectual Property Organization, and the member states which are there in the Paris Convention, they are also the part of this PCT. So WIPO, I told you that what WIPO is exactly. Why do we use PCT? To bring the word within our reach, to alleviate the burden of national patent offices, because your patentability search, your prior art searches and everything is being done by one particular organization. And it brings a strong basis for patent decisions, because PCT, all the nations also, they consider that if any application has come via the PCT route, it's been scrutinized properly for any prior art. This simplifies the filing procedure, because you have to just file one application, because there is a lot of paperwork which is involved in filing of patent applications. So this is how.
Ma'am, one thing. Let's say we have filed a patent application in India. Same documents can be there in the PCT. No need to do any additional work.
No, sir. There is a
Some other
difference.
than some form.
There are different forms, because these are national forms, which we are talking about. The form 1, 2, 3, 5. These are the national form. The process of PCT, the filing of PCT, is a totally different thing.
But the specification would be same.
Would be the same. Would be the same. The documentation part only will be different. See, basically, drafting will also be different for a PCT application, because the US Patent Office, the way the US Patent Office the filing is being done, the specification is being formed in the US Patent Office, is totally different from the way it is done in India, or for that matter Africa. They have different things, like for example, they want their figures to be numbered in one particular manner. They are usually, the attorneys are over there, the examiners are reading in one particular manner. So you need to draft it accordingly. But the concept of it, or what all is involved, the claims inside, they will be the same. There you don't need to change. So how exactly it happens is, at 0 months, suppose you have your first filing, then taking that priority, within 12 months you can file your PCT application, and after 18 months, the international processing, including centralization, search, examination, everything will be done. And after 30 months, you can take it to the individual nations. The timelines are, this is a timeline showing that you can file the PCT after 12 months, then you have after 16 months you have an international search report being formed, then 18 months there will be international publication, then you have your demand for international preliminary examination, and you can go to the individual nations. So it was like at 30 to 31 months from the filing of the international application, from the earliest priority date, you can have your priority being claimed. And the patent application is subjected to all the patent laws, internationally, the regulation and practices, later on into individual country. The rejection on form and content may not be raised, provided that they conform to the regulation of PCT. The PCT has its own way of doing things. How it helps, basically, what are the advantages? It cuts the major costs of it. The translation of patent application into various languages, because again the language is also concerned. In European countries you have 40 different languages. And the official fee for payment of the national and the regional patent offices is again, you are cutting down on that, and the fees for the local patent agents and attorneys, because some part of it has been considered. So this is all about patents, basically. What all the forms are needed, what all the fees is there, how the startups or the education institutes being held. Now coming on to the designs. So what is a design? Design is basically when we are talking about the aesthetic aspect of something, just by appearance, not the functionality of it. Usually people are confused with what is the difference between patent and the design, and people many a times say that we want to file a design patent. There is nothing called as a design patent. There is an industrial design registration altogether.
Let's say fan. Let's say one shirt is there. Shirt.
Mm-hmm.
It can be decorated with something. That also can come.
Yes, yes.
That can also be.
The aesthetic appeal of anything can have a. So these are the different designs which one has a registration
For
on.
toys also?
Yes, for toys also.
Including color.
Including color, yes. Color. नहीं, color के basis पर भी आप बोल सकते हैं.
Let's say a toy.
The look and feel, दिखता कैसा है? दिखता कैसा है? नहीं वो सब नहीं सर, वो कलर भी कर सकते हैं। जैसे ट्रेडमार्क में आप स्मेल भी कर सकते हैं, स्मेल को भी आप ट्रेडमार्क कर सकते हैं। स्मेल को कैसे ट्रेडमार्क करते हैं वो तो हाँ सर उसका मतलब उसको आप क्वांटिफाई वाला नहीं होता उसमें होता है कि ये वाला स्मेल जो है सिमिलर स्मेल अगर यूजुअली मैंने कहा ना ये सारा IPR इंटेलेक्चुअल प्रॉपर्टी राइट्स है नेगेटिव राइट्स। क्या कर सकते हो नहीं बताता, मेरे जैसा कोई नहीं कर सकता, ये नहीं वाली चीज है, नहीं करना, मेरे जैसा नहीं करना। तो पहले करना है फिर उसके बाद दूसरे को मना करना है कि नहीं करना है, तो ये आर नेगेटिव राइट्स। तो अगर आपका लगता है आपकी चीज यूनिक है, दिस स्मेल इज यूनिक, किसी ने सेम बना दी तो आपको मना करना है उसको कि तुम नहीं कर सकता, ये सिमिलर है। फिर समवन विल जज इट, जो एग्जामिनर होगा, ऑन दैट बेसिस दे विल डू इट। ऑल्दो स्मेल इंडिया में फ्रेग्रेंस का नहीं होता है ट्रेडमार्क, ये मैं आपको US का बता दूं कि US में ट्रेडमार्क स्मेल पर भी होता है। सर ये अच्छा ट्रेडमार्क में आप कुछ भी ना जो नेशनल सिक्योरिटी का होता है, वन कैन नॉट गो दैट। कुछ भी आपका ऑब्सीन होता है वो वन कैन नॉट हैव अ मार्क एज ट्रेडमार्क, तो ये ट्रेडमार्क का होता है। तो any property mark, like what cannot be a trademark that defines.
Let's say Tom and Jerry. Take a dog and cat. Whether that same story.
For what?
Some story. Instead of Tom and Jerry, you can put dog and cat.
हाँ dog and cat आप करिए, कार्टून बनाइए। तो वैसे जो आर्टिस्टिक वर्क होता है ना वो ट्रेडमार्क होता है, जो आर्टिस्टिक वर्क है वो कॉपीराइट है। now कॉपीराइट का people are confused about copyright also. कॉपीराइट जो भी आप लिख के दिखा सकते, you can write it, express it on paper, that is a copyright। उस पे फंक्शनैलिटी है नहीं है doesn't matter, दिख रहा है जो जैसा दिखता है ऐसा एग्जैक्टली कोई नहीं बना सकता, ऐसा आप किसी को रोक सकते हैं। वही नेगेटिव राइट है, आप कोई नहीं बना सकता तो बना ले तो रोकना है आपको, दैट इज द ओनली थिंग व्हिच यू कैन डू व्हिच इज इन योर हैंड। तो वो आपको जो प्रोटेक्शन मिलती है वो किसी को रोकने की प्रोटेक्शन मिलती है। So artistic work cannot be, you cannot have a trademark on. There are few non-registrable designs for which you can have anything which is sign or national anthem, emblem, flag, you can have a trademark on. Again, this occupying. Here we have come to the design. So what design requires is the novelty and the originality. In this there is no prior art publication. So this is how it is different from the design, from the patents. It should be significantly distinguishable. It should not contain anything scandalous or obscene. It should not be against public order, all these things. And it should not be included in the trademark or copyright. Because if something which is like a logo, which is used for the trade, and you are saying that I want to put it in a design, so one should have a proper understanding of what exactly IPR one should have on their work. So for this, for design filing, all the design filing is basically done in Kolkata office. So the office for filing is at Kolkata. Although filing can be done at the individual offices, but what all examination is done at the Kolkata office, and later on when their examination report also comes, they have to submit it at the Kolkata office only. The fee, the application fee which you are asking for the design is 1,000 rupee for individual small entity or startup, and 4,000 it is for others. There is this design filing is simple because there are not multiple forms which are involved. There is no request for examination as such, which is another form which is involved. There is this application form 1 which contains all the details of the applicant, the nationality, the class, the name of the article, the priority data and signature and date and all those things. Then in design what is needed is because it is all about the aesthetic appeal, the views, the different views. So they say that there should be 4 views: the top view, the bottom view, the rear view, the front view, the back view. So these are the different views which needs to be submitted to the patent office in case of designs. Unlike patents wherein we need to file the claims, we should have all the individual details. Then we submit form 24 if for startup or educational institutes, otherwise they do have all the papers wherein they can show that the students are getting educated at us. But for startups, if you are an incubator and you want that your startup should be getting the benefits of the patent office reduction of fee, then they should all get themselves registered at the DPIIT, wherein you should have the registration certificate that you are a startup. And with that certification only, one is getting the the patent office confirms that you are a small startup or a small entity, whatever. So this is the example of
If
you.
suppose startups can directly would like to file the patent,
They can do it.
so how they will get with the attorney?
How they will interact with the attorney. They individually go, they look out for the search. For example, if there is an incubator which is involved.
If the fee of the attorney will be
Yes, sir. It depends. See, that service fee is altogether different. It depends from attorney to attorney. It depends from the firm to firm. There are few firms which are charging less. There are few firms which are charging less. Then there are few attorneys which are, the work of which we find that they are not that good, but they are filing at very less price also, just for the sake of filing the number, increasing the numbers. So you can get diverse things, but if someone finds a very good thing in they find that it's worth it, their invention is, they always look out for a good attorney and then only they do the filing and all. So importance of design is that it helps the consumers to recognize any product. It makes a long-lasting effect on the consumers, adds value to the product, and you can file for a infringement if you have a design registration on your name. Duplication of design product, you can inhibit, you can restrict someone, and it gives a unique selling point to your product. In case of trademarks, what is important in case of trademark is, as you know, that it is a mark which can be a word, a name, a symbol, or a device, anything like that. What is important in case of trademark is that it should be distinguishable, because their trade should be distinguishable from the other trade. So when a trademark application is being examined, it is examined on the basis of this only. It should be distinguishable. It should be the mark or the word should be unique. And again, the trademark, for example, in case of patent, we do a patent search or the priority search. In case of patent, we do the class search. In trademark, we do the class search. So in what category, in what particular class, your word mark. So this Indian Patent Office has these different classes. There are 24 classes, 32 classes in which the different domains have been diversified. So depending upon you need to select your class. So the thing which is important is the trademark search, wherein you search the class in which you want your application to be submitted. So it provides all the exclusive rights in a particular class of goods or services. It is required for the business entity, identifies the goods or the origin of the source. So these are all the trademarks. As I told you, you can have it on sound, shapes, your taglines, certification marks, collective marks, trade names and all. Distinctiveness is very important and they should not be deceptively similar. So example of deceptively similar is this. So you can have Bisleri in all multiple ways being written, but they are deceptively similar. So you find out the spelling of it.
So, other things can also be a trademark.
No sir. ये जब फाइल करेंगे ना सर, ये ट्रेडमार्क के साथ भी वही है, आपको मिल भी जाएगा ट्रेडमार्क. This other brand may get a discount. मगर जिस दिन they are in the market and they are trying to sell it, and Bisleri actually identifies it, कि they are selling it on similar to our name, they can immediately ask कि बंद करो. You are getting those rights you have, the negative rights to restrict someone you have. So if your mark is registered, unregistered and it is still pending to be registered, it is to be examined and all, you can write a TM. So if you have done a...
गुटखा वाला केस तो very famous है, मुंबई हाई कोर्ट जजमेंट जो है.
किसका सर?
गुटखा वाला जिसमें गुटखा का कुछ केस. ये इंस्ट्रूमेंट का मेन चेक करना पड़ा.
सर बहुत सारे रेफरेंस हैं, जहाँ पे आपको नाम बाद में हमारे प्रोग्राम्स थे. हाँ, नाम चेंज करना पड़ेगा या आपको ऑल टुगेदर यू हैव टू पुट इट आउट ऑफ द मार्केट विद दैट नेम.
ये जो अच्छा वगैरह जो
अच्छा अच्छा, हाँ 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 हाँ, और आपकी क्लास के ऊपर भी डिपेंड करता है, तो यू हैव टू बी आंसरेबल लेटर ऑन। आपको मिल जाएगा मे बी, बट फिर बाद में आपको ऑब्जेक्शन आएगा, फिर उसमें आप यू नीड टू बी आंसरेबल। बट अगर आप ऑलरेडी मार्केट में हो, अब अपना मार्केट में नाम चेंज करना, इट्स बेटर कि आप पहले ही अपना सर्च कर लो कौन सी क्लास में फॉल कर रहा है, ऐसे मिलर नेम्स तो नहीं है। फॉर एग्जाम्पल देयर इज दिस वन सीड कंपनी विद द नेम ऑफ BBC, वो था बाबा बीबी चंद सीड कंपनी, वो BBC। अब BBC फाइल कर दिया ट्रेडमार्क, BBC का ऑब्जेक्शन आ गया कि द BBC जो हमारा ब्रॉडकास्टिंग, हाँ ब्रिटिश ब्रॉडकास्टिंग, कि हमारा दिस इज आवर नेम, हाउ कैन दे यूज द BBC। तो अटॉर्नीज बैठे हुए हैं चेक करने के लिए, दे विल कम लेटर, यू कैन फाइल इट प्रेजेंटली बट दे विल कम लेटर, तो बेटर है आप सर्च कर लो पहले। Trademark registration is for, you are getting the registration is for 10 years and you can further, you can renew it. For trademark, you have to file this form TMA which we do, and this is, it can also be filed online using this comprehensive e-filing. As I told you, therein you have this, when we come to this particular site, there is, other than patents, you have the trademark also. So you can select the trademarks and then fill it. So you have your comprehensive e-filing for the trademarks also. You can select that and then they will take you to different site. Then you have to log in again and you have to you can do the trademark filing on your own. So basically, patent agents or attorneys are not needed as such if you have a fair knowledge of how to write and do things. The prescribed fee for this is for individual and startups, it is 5,000, and for 1,500 if you are filing online. For all the things, your online filing is cheaper to your offline filing, your physical filing. And in all other cases, it is 10,000 and 9,000 if you are doing an online filing. Again, as I already told that in emblems and these things, they have restrictions on filing. Now coming to copyright. So these are again bundle of rights which are there for the creative work. These are for the literary work, the dramatic, the sounds, artistic, musical, or any cinematographic work. What it gives is you the economic rights and the moral rights. What are the economic rights? Rights, if you can give someone the rights to produce, to distribute, to create derivative works, to communicate it to the public, to have your public performance. So these rights one can, if you have a copyright on your name, you can give the other person all these rights. And moral rights like right against, like you should not distort it, whatever being given to you. You should have recognize the.
Let's say something mirror image.
Mirror
Let's say
image.
some symbol is there. Whether something mirror image of such symbol can do.
Some mirror image trademark.
Let's say trademark.
So trademark if you can file. That is not a problem, but objection can come any day. You have to be answered. You have to be answerable. So, if I being an attorney, I will say don't do it. Because
under derivative category.
yes, so why to get into trouble later? Better to
कुछ ऐड करना पड़ेगा
हाँ कुछ add करना पड़ेगा, कुछ make it different, make it unique.
not also कुछ
But it should be distinctly different.
Distinctly different. Deceptive नहीं होना चाहिए.
Let's say 9 feet are 1 thick mine. If you do make 2.
The distillery के example था तो they were deceptively similar, right? और deceptively similar कितनी बार, for example, हमने क्षितिज का trademark किया था. ये filed for क्षितिज, a program which was run by IRI PUSA और ZTM incubator. हमारे को शॉक स्टॉप से आ गया objection, क्योंकि वो S था. That was single S. With a single S था, but उसको साथ में एक और S ऐसे करके वो किया हुआ था, just to have. But it was deceptively similar for Shopperstop, not for us. हमारे लिए वो अलग था. But Shopperstop ने कहा कि नहीं, this is like, तो हमें because opposition की हमें वो लेना पड़ा वापस. So this protection for copyright is for maximum for 60 plus years. And this is for this gives you 25 years from the year following the broadcast, since the time you have done the broadcasting. And 50 years in case of any performance right, 50 years from the year you have done the performance. Again, in case of copyright, the fees for the literary, dramatic and the artistic or musical work, it is 500 rupees. For artistic work which involves the goods and the services, it is 2000. For sound recording, 2000. And for cinematography, it is 5000. For copyright, there is this form 14 which one needs to file through e-filing, and there is this payment of the fee which I have told you before. How exactly copyright happens is you submit your application, then it goes ahead for your scrutiny by the copyright office, and if they found any discrepancy, there comes this discrepancy letter to you, you need to answer it. If you answer it, well and good, and it is being accepted by the registrar, they give you the registration of copyright, other else they reject it. A hearing can also be done in that case. So this is all about the filing of intellectual property when it comes to different domains of intellectual property, which GI is also there, but GI is again, I think so, it is not following the law, so I'll just skip it. So if you have any question related to filing, you can pretty much ask, or should we move to the next?
Your questions are there.
Yes, sir.
Okay, so ma'am, I'm from computer science department. So suppose somebody is developing some software which is not readily implemented, not implementable in a hardware component. So where one should, apply for? So whether we should go for...
So we say that for apps and all these things, we say that go for a copyright. But copyright doesn't give you much of the protection because it doesn't cover anyone can, because it is something which you have already written. Anyone can write down the same codes, the similar software, if it is easy to write, put on, have an improvisation on. So there are ways by which we try to draft our patent application in a manner that we write it as a system, or we try to integrate in a manner that it doesn't come out as a software altogether. So it can be done, although it is a bit tricky to put it into a patent form. We also suggest that if it is that unique, that you feel that no one can easily copy it, go ahead with the copyright. Because when it comes to public thing, anyone can copy it. So for softwares, we usually trying to draft our applications in a manner, because they are coming to us, that it should come out as a system. Or if it is, it can be integrated to a hardware, the well and good, we try to put it in that way.
Yeah, actually, a lot of softwares, mainly apps are coming up, which are actually implemented in either Android platform or iOS platform. So, these are the two major, platforms where the apps are coming up, mobile apps. So, the point is, when somebody is applying for patent.
Apps usually, sir, because with patents, it gets difficult.
Yeah.
With apps, we are suggesting that go ahead with copyright only. Copyright is the only provision by which, or for example, you are having an app, you have this software component, the app component being have a copyright, and then try to look out for trademark if you are trying to put it in public and you want to have it, or to advertise it later. Put a trademark, get a trademark on it.
So you do provide support for this copyright and trademark application also?
We at PUSA, sir.
Yeah. And the other,
Khurana and Khurana, Dr. Shweta Sharma, they definitely do. We are restricted because otherwise it will be a lot of work for us. Other than ICR institutes, if we try to cover it, we otherwise also are having a lot of work at ICR. But yes, with Khurana and Khurana, you can definitely get in touch. Any other questions, or should we start with the ribbon? Yes, sir.
Actually, there are a lot of crafts which have been traditionally made by the household movements. craft which have been made by the household women, and they learn from their ancestors, and it is passing on. But it is particular for the particular reason. So
Go for a GI. If it is for a region, you can have a GI.
GI, but
GI.
can we sell it as commercial rate without questioning other people?
See, if it is a craft and does that craft have anything unique to itself, like?
I'm giving another example. So I don't know how you call that. We call it as a lorry, or something we can call it as a bucket.
A kind of basket.
A basket.
Okay.
So if I want to sell it on Flipkart or Amazon or something, so can anybody object me by selling?
No one can object you. Your concern is that no one should copy it. Is it like that? You don't want people to copy it, right? So suppose you find the design unique. You can have the design registration done. If you find the design unique, it is looking different. The feel is different. The look is different. It is different to the eyes, to the appearance. You can have a design registration done. Take different views picture, get it registered in the design.
Same way as we are doing.
Yeah, and then go ahead with the design registration. If the design is unique and it belongs to a particular set of people who are using it, so that way if someone copies it, you can restrict them not to do it. Because functionality is not different, right? Herein you cannot have a patent as such. Nor copyright or trademark will work. Trademark is like, for that you can have a trademark also. Suppose you want to put a name to that basket, like as you said, there is a name. You want to put those, you get a trademark on it, on that word mark on it. So this way, like these two IPs, you can secure it.
Thank you.
But trademark is not some particular brand.
You can also sell it for business purpose, as you say. He wants to sell.
But that comes under the traditional knowledge, so kind of, that is a kind of folklore or.
Ma'am, patent नहीं करे ना.
So it's not coming under the patent, but at the same time it's not going for the design also.
Design वगैरह unique है.
Together, it's an NGO, some community activities. So
It's not a community.
Mm-hmm.
People are.
I understand your thing.
Mm-hmm.
The product which he is selling, we manufacture with the bamboo,
Public
So देखिए, अगर ऐसा है कि कम्युनिटी है, तो कम्युनिटी राइट्स आप जीआई के थ्रू प्रोटेक्ट कर सकते हो.
That's what I'm saying.
कम्युनिटी राइट्स आप जीआई के थ्रू कर सकते हो. उसमें पूरा कम्युनिटी नीड टू गो टू द दैट एंड दैट गोज टू गवर्नमेंट एजेंसीज ओनली. उसमें आपको गवर्नमेंट जो नियर बाय आपका गवर्नमेंट पर्सन होता है उनके पास जाके आपको बोलना होता है कि एंड दैट पीपल कम्युनिटी पीपल they should write it in there is a form and through letters and all you need to approach them.
That is legally protected.
हाँ, वो वैसे फिर आपका जीआई टैग के थ्रू प्रोटेक्ट कर सकते हो. अगर ऐसा है कि the whole community is involved. Okay, so now enough of how IP filings will be done. Another very important aspect, the most important aspect of having an IP secured is that we need to put our inventions from lab to market, from lab to launch. Now what is this commercialization aspect of intellectual property? How intellectual property is going to help in the commercialization and how exactly the invention can be taken further to innovation and to market and to commercialization and all. So there are some basic setups through which we can go ahead step by step. So what is covered in this presentation is the process of innovation, the technology readiness level, which we say, the technology transfer and commercialization aspect, but which one needs to take care of. So what is the difference between invention and innovation? Invention, as we have already discussed, आगे बताइए. अभी मैं just giving a brief, but all will be good. Invention or innovation में how exactly what is the difference between invention and innovation is invention आपका creative mind, novelty and all those things आपने सोचा idea को now you have to put it into a commercial aspect wherein you want to put it into the market, your invention. What all work you have to do to get it into that or implementing that idea into actually market or fetching benefits out of it is what is called the strategies or the distribution or the business model or the charges which you have to identify is what we call the innovation. Okay, so there are two scenarios. You have an invention, you get it conceived and you have your IPR secured on it. Then you have your invention already being granted, patent is there. Now you have to do a market search. You need to know what is the value of this particular or the patent. What is the patent? What is the value of this particular patent in the market when we are going to commercialize it? So you need to have a validation and invalidation of that. So what is innovation? It is a process which involves transforming ideas or concepts into practical, valuable products, services, or processes. So step one is your idea, which is being generated. It needs to be mobilized. There is this advocacy or experimentation which is involved. You are coming to a solution in your mind, through your mind, and then you have your commercialization. Okay, fine. So, identifying a problem. You have your problem being identified, and then you look out for improving that problem or a product or a service, whatever you are getting from that idea. And then you are doing a market survey report. So usually what happens where the startups being asked is that do a survey. Do a survey that exactly your invention before coming up with a product or an idea being taken into a product or a process. Look out and do a survey that what exactly the market actually needs. How you can improvise your idea or how you can put in your effort so that your idea can be taken out further into the market for the commercial gains.
Kind of problem validation.
Yes, problem validation. Now research and exploration. You know the problem now. You know that what needs to be tackled. Now how to do it. How exactly to find the answer to it. So exploring the potential solutions to it. Or the ideas that could address the problem or the whatever the opportunity is. Doing the brainstorming and trying to identify, having sessions to people, either taking it or giving it so that you can have a better understanding and you can think creatively and can collaborate with people. And then there is this concept development wherein once the ideas are generated, they are then refined into proper concrete steps. There is this prototype modeling. So you have your idea secured, you know where exactly you have to go. So you need to have a prototype ready for it. Fine, we should be making these all are the different tasks, these all will be the different parts of my innovation if it is a product or if it is a process, these all are the important aspects which one needs to cover. Then evaluation and validation. Fine, your concepts are there, you know, but do they actually have a market value? Will they be that feasible? Do they have the potential to be a good startup later in the future? So concepts are evaluated against criteria, the market demand, because everything demand and supply. You need to make things which actually the market needs. That's why the surveys are important. The potential impact and how to, if a product is already there, how to make a product which is better to it, which is at a lower price point, or how you can improvise or you can do tiny things so that you can give a better product. The feedback from the stakeholders and the potential users, so as to validate the concept. So it requires the development and implementation. The project is, when the concept is approved, it moves into the development phase. So now you have everything in your mind ready. Now you are looking for people who can develop it. And they can refine it so that a final product can be formed. And then there are iterative cycles of design, testing, refinement. Just having an idea, having an IPR on it is not the only thing which one should, it ends with it. Final thing is that you need to take it to the market. So then commercialization. Commercialization again, you want to know what are the partners, how you will be the industry partners to whom you should approach, what should be the price point which you should keep. So at PUSA, for example, because we are basically dealing with the technologies and with the seeds also. So there is this price point which we decide, and there is this whole table wherein everything needs to be considered so that a price point can be decided for one particular technology or one particular product. Then diffusion and implementation. So this is basically two sides of the same coin. So how exactly you are gaining the final or the company-wide acceptance of how exactly you should move with respect to the mindset of the company that you should do, and then exactly making the product like that. And number, for example, the company thinks that you need 10 products or 15 products or 20 products, and working upon it exactly. So you are diffusion and implementing that. So launch and commercialization. Now that once the solution is there, the refining is being done, then you want to launch it into the market. Now it involves, when you want to put it in the market, you want that it should be, there should be a market distribution. You need to know exactly to who will be your competitors in the market, and what all price points you should be keeping so that the competition should not be there or the competition should be less. And this is to bring the innovation exactly with respect to the consumers also, who are the final people who will be taking your technology. So this is monitoring and adaptation. So at every point you need to monitor, and then accordingly you need to change your, what all idea do you have, or how all you can improvise, what all small tiny things which you can change so as to make it a better product, so as to finally put it into launch, so as to bring directly into the market. It is important to monitor the performance of the innovation and get the feedback from the customers and the users, because they are the end users. We are just there to have the gains out of our product. So need to meet the demands of the people. And this is very important so that you can make any adjustment or improvement. We are changing our, we have seen this revolution going on from our phones, wherein there were phones which were, we used to type, then we used to have camera, then now there are multiple cameras. So these all are changes which is as per the need of the people. There should be continuous improvement. This is what innovation is all about. You keep on changing into your product only. It should not be like full and final. This is my product and fine, it's okay, we are having a market. There should be a competition within yourself. So innovation is an ongoing process. Organizations should continuously seek on new opportunities for improvement and innovation. Having an IPR on it and sitting on it, that fine, I have an IPR. You need to sell that IPR too. The IPR is basically to put it into the market. It is essential to assess the maturity and readiness of a technology. What is readiness of a technology will come now. So if you consider the startup, this is the life cycle of a startup, where there is an idea stage, wherein we explore the ideas, think that we should be making this particular thing. Then there's the seed stage, wherein we get the seed funding from small fundings we are getting from here and there, from the government also, from then there are private funding agencies too. Then present your long-term profitability to venture capitalist. Then comes the venture capital. When your invention is at a particular stage, and these venture capitalists are ready to invest in your startup. Then you refine your product and grow avenues by attracting series of investors who can invest in because now your product is about to be put it into the market. And then there comes this maturity stage where your startup is now no more a startup, it is a business now. And you have put it into a growing phase wherein it can survive on its own. You have all the tactics, you're knowing it, making it into either merging it with a bigger company or making it a bigger company in itself. For all the startups, wherein all the incubator is having different startups, what is needed is the Startup India certification, the department of, and this is not just with respect to the intellectual property, like the fees and all. Otherwise also, many times you're getting funding because you are having this particular certificate. So we encourage all the startups to get yourself registered first. Yes, DPIIT certificate. Now comes the technology readiness level. So, what is technology readiness level? We have our technology in hand. We need to know at which stage is our technology so that it is ready to be put into the market. From lab to the market it is to be launched. So it is a measurement system which is used to ask the maturity level of the different or a particular technology. So each technology project is evaluated against parameters of each technology. For example, if there is a machine, it may have a different TRL levels. If there is a formulation, it may have a different TRL level, because maybe the TRL level of machine, which is a device, which is having a structure, it may be different for any formulation wherein not much changes need to be there. A machine may be that it is at a very initial level only. With the one prototype ready, you can put it directly into the market. Maybe with the recipes, you need to have the certifications. You need to have from different organizations, you need to have all the certifications ready. So the readiness level can be different for different technology altogether. So totally we have these 9 technology levels wherein this TRL 1 to 9 we differentiated. The lowest being TRL 1 and TRL 9 being the highest one. So what is this TRL level? These are the specific stage of the technology development with respect to the startups which they have been given, with the higher levels indicating the greater maturity. So if you by the grade, this is basically grading system by which you can grade this particular startup is at this particular level presently, and we need to come to the next level now. This is for the readiness of for deployment. So what are the different TRL levels? So these are the 9 different TRL levels. We start with the basic principles being observed. So this is the my technology is at TRL level 1. It is that we have just identified our technology. Now there is this technology concept being formulated. Now we have everything on the paper, we know how exactly to proceed with it, we can talk and discuss about it. Now there is this experimentation proof of concept ready, we call it TRL 3. If your technology is at this particular stage, you can take it ahead to TRL 4, or if it is like that, you can come to TRL 3 stage. Then technology needs to be validated in the lab. Suppose you have validation in your lab though, but you need a validation and through a particular agency, which is like a government standard, you should need to have a validation from them. Technology validated in relevant environment. It's not important, it is at this particular environment that you have given a TRL level 4. Now you wanted to put it into a particular environment, then you want to see how exactly your technology will work. We give it a TRL level 5. Again, in one particular environment if you want it, then again, this is again getting very specific. You put a TRL level 6. Then a prototype is ready. You want that the prototype you can show it to people around, or you want to put it into launch now. You put it at TRL level 7. Then your system has qualified all these TRL levels. Now you are good to go to the operational level wherein you can sell you can directly go to the market stage. We call it the TRL level 9. Now, what is the importance of this? The importance of this is that because when we know the TRL levels, when we know this is the way this is helpful for us to transfer our technology, to facilitate the technology transfer from research laboratories to the complete commercial applications. Now, when we say, fine, a company has approached us that we are interested in your technology, but we should be knowing that, fine, is it at that stage of being formed, that at the final stage where it can be taken to the laboratory, or is it just at the prototype level, or maybe more validation is needed. So it is important, this TRL levels, whatever level we put it, it is important for the technology transfer. For risk mitigation, wherein organizations can identify the potential technical or financial or operational risk which is there with the technologies. Then decision making. These TRL levels, on the basis of these TRL levels, the decision making by stakeholders who are putting in their money, it becomes easy for them. That it is at this particular level. Should we go ahead with it? Should we not go ahead? Will be it a future? Will it be for a future benefit for us? And it gives you the resource allocation, wherein they can prioritize the investment aspect of it. But how much amount of money you should be initially putting it in. So there are, these are the real life examples. For example, biomedical devices, they have been given this TRL level 4 to 6 or 7 to 9 to evaluate. Then you have your renewable technologies, which are again judged on the basis of the TRLs. The military technologies also. You have your autonomous vehicles which are being given it. So these are for startups. If you are having a particular TRL level and you are putting it into the market, on the basis of your TRL levels, the people will be interested in investing in your inventions or your idea or your innovation. Now comes the technology transfer and commercialization aspect. Fine, we have your technology ready to be commercialized. People are interested in taking it. What things you need to consider when you are doing a commercialization? Because what happens is at times people, they say, fine, at least I have got a company in hand. We should give everything to them. They are at least, they will pay us good. But there are things that which you should be careful about. For example, if you are having a technology, you are having an IP also on that, and you are giving it to the other person. Now the other person, because you have given all the rights to the other person, they can do all the changes. So in the agreement, when you are doing a technology transfer, you have to tell the know-how of the technology. When you are telling the know-how of the technology, basically you have given all the information to that person. They can easily give it to any other person and get the benefits out of it. So an agreement needs to be made, a contract needs to be made wherein all the key points, like we are just transferring you the know-how of the technology and you cannot transfer it to the other person. It should stay with us. It should not come to you. The IPR of this technology will be with us. It will not be transferred. And even if you are doing any improvisation in the future, this IPR, you will be including us. If you will be improvising our technology only, you will be including us in the future IPR. So these all benefits which you want from when you are selling your technology, you need to put in on paper in the contract agreements and all. So in intellectual property, you can have your industry, institutions, individual and organization on the basis of their skills and the intellectual property or the methods, you are coming into the commercialization level. So in technology transfer, what we are doing is, this is the process of transferring the knowledge, other than what all your invention is having, all the skills, the technology know-how of the thing, you are giving it to the other person. You are also giving the IPRs related to it to the other person. And the purpose of it is to have the commercialization or the future development. So all how exactly the skill set of the people that is also being transferred. So there are the industries involved, the institution. At times it happens the institution wants to keep some rights to themselves.
So how it differs from the license, giving license to, is it the same thing?
Yes, giving licensing, it is an agreement only. It is like a contract only. So you are having your technology ready, now you want to transfer it, you need to have a contract. And in that contract, because contracts are usually having many things hidden in it, so you need to clarify it. This is like proper legal, all the big companies, they have their proper legal cell involved, wherein they know all the details. So they may skip, they try to put in everything in their code. So you need to consider it at time. We need to have our rights which are with us. Not everything we need to give it to them. For example, organizations, how do they do is, like for example ICR.
So if somebody is selling that technology and transferring that technology by taking some, lump sum money,
so yeah, there are.
You don't have any say to
Yes, if you are giving it exclusive, we call it exclusive licensing. So if you are exclusively giving everything, so you don't have any say in the future. And if the thing is like that if the know-how of technology is gone, everything is gone altogether. For example, there is a machine, you are giving a blueprint of the machine. They have the blueprint now. They will make multiple machines, they will improvise it, they will make another machines. But in the agreement, you need to tell them that if you will be giving the blueprint of the machine, you are not ready to, first of all, you will not be making without our knowledge. This is not exclusive to you. Others can also make it, it is up to us, whosoever is making it. You can only make it, you cannot further pass on to others. So these are all things which should be there in the agreement.
For the academic institute, which is preferable?
So for academic institute, for example, ICR, when ICR is doing any agreement of this kind, they keep everything with them. They are giving the non-exclusive licenses only. So ICR is the applicant, the IPRs are also with the ICR only. They are not giving it to the company.
Because they are यहाँ पे complete transfer नहीं होता.
नहीं not flexible.
हाँ नॉन एक्सक्लूसिव देना होगा. उसमें कंपनीज बोलती हैं, वो परसू करती हैं, वो परसुएट करती हैं आपको कि आप हमें आईपीआर तो हमें दोगे, हम इसको चेंज करेंगे बिकॉज दे कैन डू इट. फिर वो कॉन्ट्रैक्ट रिसर्च के थ्रू भी हम बोलते हैं कि ठीक है आईसीआर में काम होगा बट आईपी विल बी ऑफ आर्ट्स. इसमें आप यू विल बी गेटिंग अ नॉन एक्सक्लूसिव लाइसेंस ओनली. आपने कुछ किया उसमें आपको इंक्लूड करना पड़ेगा आईसीआर को. आप एक्सक्लूड नहीं कर सकते हो ऑल टुगेदर. अपने आप को इंक्लूड करोगे क्योंकि आपने काम किया है उसके ऊपर बट यू विल हैव टू इंक्लूड अस.
Majorly just to add Dr. Gupta's point, exclusive licenses are very less.
Less, no?
Mostly they are being given by like some startup is there, and if it is transferring or maybe they are moving abroad, so in those kind of states they are giving the exclusive license, but mostly the institutes are recommended to go for the non-exclusive license because they cannot rely on one particular partner and they cannot make the and agreement really needs to be very strict and proper. Each and every clause needs to be written very properly because that can create a hassle later on. So you cannot transfer. You have worked on it and you will keep on working on that particular technology. Now you will not stop there. So later on, if somebody else is having all the rights, they can come back to yourself. They can say that you are infringing them. Getting my point? So that's the thing. So you should never go for the exclusive license.
And ma'am, let's say we have internal faculties or students startup also. Okay? We can give them non-exclusive also.
Yes, why not? Anybody, just you should have an agreement.
No, usually what happens, those who are faculty members or students, we are allowing them, their IPR, what about they are the inventors, we are allowing them for the startup, initiating a startup, based on their institute we will be having some equity. If it is on equity basis, then we can give them non-exclusive.
Exclusive doesn't go with not at all.
Sir, exclusive simply means that you have sold everything. You have a
Exactly.
You have sold.
You have no say on it. You have no say on it.
Say on it later.
हाँ बोल ही नहीं सकते कुछ बाद में आप मांग ही नहीं सकते ना कुछ सब कुछ तो दे दिया अपनी टेक्नोलॉजी पूरी दे दी. So academic institutions, as I told you, that academic institutions, all the government bodies, laboratories, they do this non-exclusive thing wherein they are the whole, so inventors are the part of it. Then there are these large companies who are ready to merge with the smaller ones for their licensing and all. Or you are making another company, small company of yours. Like,
let's say those in the line of the startup of our internal startup engineers don't have any funds. Okay, usually what is the change? If it is changing, then we cannot access it.
Do the startups. Sir, startups funding.
yeah, funding is altogether different thing. Funding is
Let's say शुरू में उनको पास कोई funds नहीं है, but based on whatever the invention they have
Sir, investors who like it based on the IPR you have, and investors are very happy to invest at the places where the IPR is protected. They feel like investing there. So the very first thing, rather than doing any licensing or anything, rather than giving your technology, they are highly recommended to bring the investors. And investors would be coming, then they should just establish their business, and later on if they feel. So I would not suggest that for establishing their startup they should have some licensing.
तो उसके लिए तो फिर क्या है, आप फंडिंग लीजिए ना, वेंचर कैपिटलिस्ट इन्वॉल्व करिए अगर आपको चाहिए, फंड रेज करिए. एग्जैक्टली
That would be better.
उसको स्टार्टअप को उसी से बेनिफिट देने का कोई वो तो आप देयर आर अदर वेज टू राइट. व्हाई नॉट टू यूज दोस वेज.
हम तो आपसे पेटेंट देने के बोलेंगे ना.
एक establish हो जाए. I got your point, sir. You are very right. The only thing is that just for establishment, they should be better finding out the investors rather than going for the licensing from day one. Once the things are set, because licensees also would not come if you do not have investors, if you are not
लाइसेंस देने से अच्छा तो आप ही फंडिंग दे दो, follow the route, no? You keep the license because that becomes an agreement, that is a contract, वो तो आप अपने पास रखिए. आप help out ही करना चाहते हैं, that is your startup only. You want to help out, give the funding on the other way around. आप वैसे भी करके help out कर सकते हैं ना, from the gains what all you have.
Let's say startup can show that they have taken the exclusive license, the non-exclusive license from the institute, and this is now working with that. And then,
But sir, जैसे
non-exclusive, let's say we are giving to the startup. Now startup and institute have a joint for this. And let's say startup will be working for the contract. And if they show that they have, yes, we are working on this, which is or share is there or something is there, then they can approach to the venture.
Yes.
That will be very easy, na, for them.
That would be done. Yes.
so बल्कि वेंचर के लिए पहले इनिशियल लेवल पर ही वेंचर कैपिटलिस्ट को इन्वॉल्व करिए.
पहले आएगा
हाँ.
तब आपको लाइसेंस
लाइसेंस वाला तो स्टेज आ ही तब रहा है जब आपका वो फाइनल प्रोडक्ट मार्केट में जा रहा है.
so that PC can pay to the institute. Institute को पैसे दिए तो कोई फाइनल लाइसेंस देगा.
Yeah, but I would get what Dr. Pradeep was trying to say कि अगर हमारे पास पैटेंट है और हम उसको अभी यूटिलाइज नहीं कर पा
startup
रहे
करना चाह रहा है.
और आप यूटिलाइज नहीं कर पा रहे, you have multiple things. So
Yeah.
there is a startup who wants to have that particular patent and he wants to use it to grow it, so you can have an agreement kind of thing with them, non-exclusive. That okay, we are giving you this rights and you just work on it, grow it.
Yes, yes.
This is what you're trying
So
to
for
do.
example,
It is like a dead paper.
Yes, that paper, yes. You can do it, sir. Why not? This is a very good idea actually.
नहीं सर, ये आईसीआर में एग्जैक्टली यही होता है. आप जो बोल रहे हैं ना, स्टार्टअप खैर वहाँ पर ये है कि स्टार्टअप की जगह इनफैक्ट बहुत सारे स्टूडेंट्स हैं, स्टूडेंट स्टार्टअप्स हैं. They are working with for ICR, they are working under some scientists. Now they want to collaborate through companies. So companies, they look out for the companies. Now the companies are there. Company और आपके जो but in all these cases जहाँ पे company involved हो रही है, जहाँ पे आपके student startup कर रहे हैं, वहाँ पर ICR plays a major role. ICR अपने आप is making the agreement basically. Students are not making the agreement there.
What is coming there? Now the venture is asking who is getting the exclusive or non-exclusive right for the patent.
Exclusive, non-exclusive right तो
Non-exclusive right. Again, who is named? Okay.
हाँ, whose name में ICR के नाम पे होगा,
तो ऑर्गेनाइजेशन
ऑर्गेनाइजेशन के नाम पे होगा.
IIT बेसिक will transfer non-exclusive license to the startup.
हाँ.
तो VC सिंपली पूछते हैं इसका IP है या नहीं.
तो
या not asking exclusive non-exclusive.
DC के बीच में और ICR के बीच में हो रहा है. स्टार्टअप जो हो रहा है उसको ICR बेनिफिट कर रहा है. तो आप जो कर रहे हैं वो जो वेंचर कैपिटलिस्ट है और ICR के बीच में एग्रीमेंट हो रहा है. बेनिफिट्स मिल रहे हैं.
What is your opinion? ICR will be giving non-exclusive to the startup? That is my question. Whether it will be facilitating for them to bring the venture?
नहीं, वो उनको डायरेक्टली स्टार्टअप्स को भी नहीं देगा. फॉर एग्जांपल स्टूडेंट स्टार्टअप है, डायरेक्टली स्टूडेंट स्टार्टअप को नहीं दे रहा है. स्टूडेंट स्टार्टअप के पास तो IPR है ही, और स्टूडेंट स्टार्टअप के पास तो फॉर दैट मैटर एग्रीमेंट में भी नाम है.
Most of the cases what is happening in the institute, let's say all the IPR in the name of the institute. Let's say student one, faculty one. Now all the IPR in the name of the institute. Now let's say whatever the IIT is there, faculty member along with his students or her student, those who are involved in this invention, they wanted to have a startup based on that.
तो कंपनी खोलेंगे सर, वो अपना कंपनी नेम होगा उनका.
Now the IPR is in the name of the institute. Then my question is that whether the IPR need to give the non-exclusive to the startup?
Yes,
Because
yes.
initially it is not in the name of the startup.
Sir, I got your point. Actually, we are using two different things. That's why we are discussing. I am simply understanding that if any patent is by the name of BHU IIT and you are just keeping it and you're not working on that, and somebody, some student or professional is wanting it to work on it, so rather than just keeping it idle, you would like to give it. So the license is, this.
Main license is in the name of the
you are missing the point.
Yeah,
That
same professors.
the inventor is there.
The startup founder.
Yes, that's what I'm
Only the
saying.
startup founder भी है.
So inventors are there, so inventors के पास से right तो नहीं होते ना, applicant के पास से
बिल्कुल, applicant जो है institute है.
applicant
एग्जांपल है हमारा कि ICR में देयर वाज अ स्टूडेंट स्टार्टअप, उन्होंने अपना कंपनी, अब दे हैव, उसने अपना कंपनी ही खोला। सो द साइंटिस्ट वाज देयर, द स्टूडेंट वाज देयर, स्टूडेंट के नाम पर उन्होंने कंपनी खुलवाया। अब कंपनी के साथ एग्रीमेंट हो रहा है ICR का, क्योंकि कहीं ना कहीं साइंटिस्ट इज इन्वॉल्व, कैपिटल को लेकर आ रहे हैं, कहीं से वेंचर कैपिटलिस्ट को लेकर आ रहे हैं, वो सब कुछ इन्वेस्टमेंट हो रही है। जो एक्सक्लूसिव, इसमें नॉन एक्सक्लूसिव लाइसेंस बन रहा है बिटवीन द स्टार्टअप और द व्हाटएवर इट इज एंड ICR, ये एक नॉन एक्सक्लूसिव लाइसेंस बन रहा है।
नॉन एक्सक्लूसिव लाइसेंस दे सकते हैं।
हाँ दे सकते हैं, तो उसे कंपनी खोलना ना, अब तो कंपनी है।
Sir, they will grow, they will increase the revenues, working out patents if you are filing, you will be able to file Form 27. So this is very, very good.
सर नॉन एक्सक्लूसिव में ना आप सब कुछ नहीं देते हैं, आप सिर्फ बोल रहे हैं कि आप यू मेक द थिंग्स, यू सेल इट।
What is saying na, he is just giving the right to make and do.
हाँ
And do that. That's it. You can definitely.
You are startup, you are giving equity. Whatever you are giving the approval to the faculty member, you have a startup, okay, under the umbrella of the IIT. One, let's say, same person is the inventors of the okay, and he can or she can use the patent, okay, then non-exclusive one, then it will be easy for them also to arrange the
सर पेटेंट के केस में तो ये ना, वहां पर वही तो इन्वेंटर है, एप्लीकेंट ICR है ना, तो आपका अब जो, क्योंकि IP राइट्स भी फॉर एग्जांपल ट्रांसफर होती है ना, इसमें करनी है नहीं करनी है, या IP राइट्स का भी क्लॉज होता है, तो उसमें फिर ये वाला क्लॉज होता है कि राइट्स जो है वो आपके ICR के पास रहेंगे, क्योंकि स्टार्टअप को तो मॉनेटरी बेनिफिट मिल रहा है, उसको तो मिलेगा सारा मॉनेटरी बेनिफिट बीइंग अ पार्ट ऑफ इट थ्रू अ नॉन एक्सक्लूसिव लाइसेंस। हाँ बिल्कुल, यस यस, हाँ वी कैन डू इट।
if we do that, then whatever we start up, let's say we have an investment. Now, okay, then they will go fast.
हाँ
They can attract the venture.
yes sure।
We are working in this. Okay, now we are having share or something in this. Because the institute is not going to do anything. Startup only will do it. Inventors will do it. That's the correct. We can do it.
Yes. In fact, if you can help, being an incubator, if you can help with getting them the investors, that can also be done. Getting the companies who are ready to invest, that can also be done. They themselves also will look out for things, but if you can help them out in some ways, that is a part of the incubation. So mechanism of technology transfer and commercialization, you have your licensing agreements, you have your joint ventures and collaborations, you have your technology incubators and accelerators. So then accelerators and incubators are also part of your agreements. Then you have your spin-off companies wherein you make your own company, like as I was saying, that the startup itself is making a company and then they are making a part of the organization. So licensing, what is exactly licensing it? It is a legal agreement between two parties where one is the licensor, the one who is giving the license, and the one who is getting the license to make sell is the licensee. This is how exactly the commercialization happens. And what licensor exactly is giving? It is granting the licensee right to use, can develop it, or commercialize the intellectual property, like the patents, trademarks, copyrights. So it all depends exactly what you are giving. You can give though. So there are these negotiations being made between the licensee and the licensor. A contract is being formed wherein whether your IPs are going to be transferred or not, you take care of it. So how exactly one exploits it? The licensor gives it to the licensee. The licensor can give it to multiple licensees. Like if it is non-exclusive, you can give it to one, you can give it to two, you can give it to three. But to all you are giving a non-exclusive license. So what are the licensor's obligations? You can deliver it, you can improve it, but you cannot enforce it. You cannot defend it. So benefits of licensing are monetization, you have your market access, you have your innovation, and your risk sharing. Because now you have your companies also involved. The type of patent licenses, this can be exclusive license, there can be non-exclusive license, and there is compulsory license, which basically when the government takes over. And there is this, what all is, they should be there in the agreement, it should be in writing, we should mention the scope of the license. So this is very important. Forming your agreements is again very important. Plays a very important role in the sense that each and every line has can have multiple meanings. You need to be very legally correct. The royalties and compensation you need to identify.
Sir, ma'am, you have also some advices to make
Legal? Yes, we have.
to make all these agreements.
Yes, we have a contract team. Litigation team is also there. They will help you.
So legal all these.
Yes.
Then intellectual property, exactly how confidentiality should be taken care of. These all should be the part of your licensing agreement. So what all is involved? Your partnering to customers, your patenting and licensing, these all things are the important things which are involved in the commercialization. So from science to law, the techno-legal aspect, the business, this is how the whole world comes under one umbrella. Thank you all.
Thank you, Dr. Neetika Soya, for giving us so informative information regarding IPR filing procedures and also IP commercialization. And now I would like to ask everyone if you have any questions to Dr. Gitika and Dr. Sweta, then kindly ask. We have we are already running out of time, so you can ask 1-2 questions
While
if you
having
have.
a tea also, we can ask that if any questions left. I guess they had enough for the day. Yes? I saw you clapping.
But just one,
Yes, sir.
what is the success rate in India?
Sir, very less, if I'll be honest, because most of the academic institutes you see, and I would say success rate is good for the companies, but if I talk about the academics, it's very low and we really need to put up the source. Because I don't have the exact idea of it, but what is happening in most of the institutes, they are trying to get the patent. I'm sorry to say, but because it is related to the promotions and incentives. So I have few friends who are scientists in different good institutes, and they say they just want to publish kara de, kaise bhi. And then I just make the application number de dete hain.
And number of patents and so on. That's not the issue.
Exactly. So if I say that they are, I say that they are even thinking of commercialization, is that thinking is also not. I'll be very harsh and honest.
No, it's nothing like the product has some, is suboptimal. It's a kind of inertia that we are having to, move forward for the commercial.
So, yes ma'am, because of less awareness I would say. Because awareness is also not there. But the success rate, as you asked me, it's very, very less. But we can definitely do it. Because after the grant, we think that, okay, a grant ho gaya, done ho gaya. But actually the story starts from there. Then grant ho gaya, then we have to take it for the, the large scale. And how are we going to bring, as Dr. Gitika said, the different, so the TRL level 3, 4, 5, somewhere in the lab, right? And you have to basically take it to the market and how to do, and you have to make a team who can do it. So, ये वाली चीज researchers नहीं कर पा रहे.
Just one more thing I was thinking is sometimes these patents
market survey report. आपने mention start कर दिया. Now, like I was giving an example, कि आप -40 का jacket का trying to sell in India, it won't be possible. That's where the market survey report helps. कि आपका market क्या चाहता है आपसे, है ना? Market में आपके product की जरूरत है भी कि नहीं? अगर आपके market की product की market में जरूरत है, तो you have to enforce that. आपके पास grant आ गया. Now you will connect with people. हम क्या करते हैं? Grant आने के बाद patent रख के बस लिख देते हैं patent granted. हम उसके लिए investors नहीं ढूंढते, हम उसके लिए licensees नहीं ढूंढते, क्योंकि हमें भी कहीं ना कहीं लगता है कि पता नहीं large scale पे successful भी होगा कि नहीं. So what we have to do, हम annuity पे कर रहे हैं, maintenance पे कर रहे हैं, working of example वो पे कर रहे हैं हम सारा कुछ, लेकिन हम उसे कोशिश नहीं करते कि एक बार grant हो गया तो हम उसे we should try to see to give to some lab with a non-exclusive agreement that just check it whether it is working on large scale or not, and what all products can be sold. Like if you are making a formulation, simple shampoo if you are making, then you have to connect with people. The people would not come to us. So that hesitation is there, and grant is thought as a success. कि मेरा research बहुत अच्छा है because I have got a patent granted. So that grant is stopped basically. So the problem is from our side. Ma'am, you would agree, I guess, that we have hesitation also, and we have that thing कि grant हो गया ना. So grant से story start होती है, खत्म नहीं होती वहाँ पर. वहाँ से we start, and then you have to find out. You can ask us to find out the potential people who are working in your field. So if you are working in that, so suppose you have made a media, we can connect to these who are all those companies, high media and all, they make medias and all, right? So we can connect with them.
Start before you put your research work into it. That survey should be done with respect to what you are looking for the particular one. Because basic research is different, applied research. When you are talking about basic research, that is fine. Go and do your research. When you are talking about the applied research, go and do a market survey. Try to identify the problem first. Then work upon it.
Pharmacy probably has a better
Yes,
success. Pharmacy and
for that matter.
Comparatively, yes.
But academic institutes do the reverse.
Yes, exactly. That's what I'm saying. They do the exactly different.
Because whenever let's say students have been PhD, they found that okay, we can go for patent or later see that the market.
So patents to these days are coming. Now to still it's coming. But earlier it was only publication. We were publication oriented, all of us.
And those who are doing
You
business,
have to make
let's say
an
they survey first
independent
whether I
committee
can do
members
this
to look for the companies who can.
सर मैं क्या सजेस्ट करूँगी, जितने भी पैटेंट ग्रांट होते जाए ना, just keep a line and then just put 2 or 3 people. वो हमसे कनेक्ट करें या हम खुद करें कि कौन सी ऐसी कंपनीज हैं, आपने कोई मीडिया बनाया या आपने कोई कॉम्पोजिशन बनाया, just find out कि कौन सी ऐसी कंपनीज हैं और उनको हम कनेक्ट करेंगे.
You have to have professionals who have the part-time
Exactly, that's the thing. आपको research भी करना है. आप बस time.
Now what we have decided that we will be having some let's say not government persons, those who like agents, okay, those who will be working for us for the technology transfer.
सर इतने तो ग्रांट होते हैं ना, if you hire somebody और आपके पैटेंट ग्रांट हो रहे हैं महीने के 1 या 2 महीने.
If I'm getting 73 grants in 1 year or 2 years, then we can hire the people who can look for the
Professionals who probably have experience.
Sir, we also have people who do this. They do the market survey report, they find out the commercialization team we have. So you can just put them in whatsoever patent is being granted, please find out
Share
the
the abstract or something.
No, we have all the data now. We have everything. We do not need anything. You just have to give your instruction that this particular granted patent has potential and we would like to share this mail with the commercialization team. Then they will do everything, the MSR and everything. Yes, so you might be having the SOC, we have provided the codes also for that. Yeah, if not, then I'll share. But then we have a commercialization team and technology transfer team. So you can just connect with them. Then I'll be out of the picture and those will be in.
But we should have an agreement.
Definitely, sir. They will make an agreement. And we have empanelment. We have signed NDA. So even you do not need agreement also with us. But if we find some licensees and if you're, then we'll make an agreement on your account.
They will charge.
nothing comes to me.
What, sir?
They will charge, right?
Unfortunately, yes.
So उन्होंने brainstorming करी
Then we will be having like those and that they can work
Over
in
the team,
from
we can have a
anywhere.
discussion. So,
They can work from anywhere
Yes,
else.
sir. थोड़ी परेशान हो गई।
बच्चे परेशान हैं। बस बच्चों को पूछना ही नहीं है।
Okay, so now I would like to invite Professor Abha Mishra, Associate Dean R&D, for conclusive remarks and vote of thanks.
So, now I'm here to give a formal vote of thanks. So, I'm giving the concluding remarks like as we have drawn this enriching one-day awareness program to a close, and I'm filled with immense gratitude and satisfaction that this event is a kind of resounding success. I presume this from your side that it's a success. At least we are fostering a kind of awareness in you that you can, come up with your ideas and how you can go further with the patent or a different industrial designs has different component you would have read from the experts. So now work in that area and just try to think in a different way, and it's a message to all of you. Please go through the India's need and how you can align your work with the nation's requirement and go for the patenting. You'll get the license, you'll get the buyers who are looking for the new materials or new technologies. So it's a very, very win-win situation for you to work on some emerging areas. So now I'm giving a formal vote of thanks to all the members who are present here. First of all, I extend my sincere thanks to our Honorable Director Sir for his unwavering support, which has been instrumental in making this workshop possible. A special thanks to our Dean of Faculty Affairs for his valuable insights. We are also deeply grateful to Professor R.S. Singh, Project Director IDAPT, for his address. And I extend my sincere appreciation to Professor Rajesh Kumar, our Dean R&D, for his thoughtful address and for guiding the IPR Cells initiative. Our thanks to also go to our IPR expert, Dr. Shweta Sharma and Geetika Syal, whose expertise, clarity and engaging delivery made the technical sessions both accessible and impactful. A special thanks to Dr. T.K. Nandiji and Professor Pradeep Pai, Professor Meshram, and all others who are sitting here giving their valuable time in the discussion. We are thankful to CST, UP, Government of Uttar Pradesh for their generous sponsorship, and to IIT BHU for providing the platform and resources. A big thank to all the participants and young researchers, or we can say innovators, for your active engagement and enthusiasm. Your presence and interaction have made this workshop vibrant and meaningful. So finally, as we conclude, let's carry forward the spirit of innovation and protection of intellectual assets. And I hope this would be the stepping stone for making more of patents and workshop and breakthrough. Thank you, one and all.
We'll take photo all together.
Thank you, Professor Abha Mishra, for such a nice vote of thanks. Now I would like to invite Professor Pradeep Pai, Associate Dean R&D, in order to give memento to today's IPR Expo, and all the dignitaries to come on the stage and give memento to our today's speakers.
And let's have a one group photograph with all the participants. अरे मेश्राम जी सर आइए। अरे ग्रुप फोटोग्राफ वो तो पाइप जी ले रहे हैं ना, हम लोग आ जाए सारे लोगों को वो ले रहे हैं।
सर सामने से हट जाइए।